This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
I'm for the petitioner.
Yes.
But to make the issue will not brief, if your lordship kindly takes the trouble to take up my reply, affidavit reply, where I annex the orders of the court passed from time to time on this very issue. And that will make us easier to appreciate the whole thing.
What is this? আরে মামলা ওনাদের বোঝে উঠবো না কি বলবো উঠবে না বলছি
Reply you filed?
Yes. Let kindly turn to page
Just a minute. Let me
9.
let me see where is the reply.
Order that is.
আইনটির মনে বিয়ে হয়েছে অ্যাপেল হয়েছে সেটাই
Yes, affidavit reply. Yes.
Got it. Kindly turn to page 9. In fact, this court, my lord, had gone into the matter in detail. That's why I'm placing, my lord, so that I may be able to, my lord, make your lordship understand the whole issue. May I place it?
Yes.
The subject matter of the instant writ petition is a recruitment process to the post of assistant teachers in government-aided, sponsored and junior basic primary schools conducted by the West Bengal Board of Primary Education. The qualification prescribed for the candidates relevant therein are as follows. Now, Lord, I am not troubling my lord reading the qualifications. Then paragraph 2, the petitioners before this court can be segregated into two categories. The petitioners number 1 to 4 possesses B.Ed degree as also diploma in elementary education. Now, this is the area of controversy. Ultimately, it should decide. The petitioner number 5 to 12 possess DLEd degree issued by the National Institute of Open School as also diploma from the West Bengal Board of Primary Education. The recruitment process started with receipt of online applications where the candidates were required to specify the qualifications, which was to be the primary qualification. The writ petitioners specified B.Ed degree as their primary qualification, and the writ petitioner 5 to 12 used DLEd as their primary qualification. Board thereafter permitted the petitioners to edit and alter their qualifications on 14th of December 2022. The reason why this was permitted was not stated before the court. There could be many reasons behind this, as would be evident from the discussions hereinafter. On 25th November 2022, two sets of writ petition came to be disposed of by the Rajasthan High Court, whereby non-inclusion of B.Ed qualification in the process of recruitment to primary teachers in the state was challenged. In another batch of petitioners, the notification dated 20th June of 2018, issued by the National Council for Teachers Education, prescribed B.Ed as a qualification for recruitment as primary teacher was also challenged. The Rajasthan High Court inter alia held that candidates hold B.Ed degrees could not be allowed to participate in the process of recruitment to primary teachers. The notification of the NCTE dated 20th of June 2018 came to be struck down by the Rajasthan High Court. The reasons therefore were that a B.Ed qualification is not sufficient for the purpose of equipping a teacher to teach students at the primary level. The judgment of the Rajasthan High Court was carried before the Honorable Supreme Court in special leave petition such and such. Therewith were heard two other writ petitions, that is WP 137 of 2022 and WP 881 of 2022, challenging notifications of the government of Bihar and Uttar Pradesh, which called B.Ed candidates to participate in the recruitment to the post of primary teachers. Back in West Bengal, this is the issue. A writ petition was filed by the candidates who were undergoing the DLED course to allow them to participate in the aforesaid recruitment process. The West Bengal Board of Primary Education, that is WBPP, even before the writ petition was taken up, permitted such persons to participate. The said writ petition came to be disposed of on the above. A rival group, however, filed match such and such challenging the decision of the board to permit in-course DLED candidates to participate in the recruitment process. The division bench, by a judgment dated such and such, held that in-course DLED candidates could not be allowed to participate in the recruitment process. The decision dated 11th April 2023 is now pending challenge before the Honorable Supreme Court. Initially, the Supreme Court stayed the publication of the merit list. Subsequently, by an order dated 29th of January 2024, the Supreme Court permitted the Primary Education Board to publish the merit list and proceed with the recruitment process and publish the merit list. Insofar as the appellants therein were concerned, the board was directed to conduct final interview and aptitude test within 6 weeks. The remaining post was directed to be kept vacant. And armed with the direction of the Supreme Court, as above, board had published the merit list in the selection process dated 29 September 2022. Prior thereto, on 11th of August 2023, the decision of the Supreme Court in Devesh Sharma versus Union of India came to be pronounced. The judgment of the Rajasthan High Court holding that B.Ed degree holders will not be allowed to participate in the selection process of primary teachers was upheld. The notice of the NCTE dated 28th of June 2018 was held illegal and correctly struck down by the High Court. Some proceedings in the meantime occurred in Calcutta. Another set of candidates who prayed for the option of migrating from DL-ED candidates to B.Ed candidates in the state recruitment process. We'll underline this. By an order dated 1st of May 2023, that is before the decision of the Supreme Court in Devesh Sharma, a coordinate bench of this court at an interim stage permitted the writ petitioners to migrate as B.Ed candidates instead of in course of DL-ED candidates. The said petitioners possess both qualifications. Underline this. The board was directed to allow such as an interim measure to such merit the writ petitioners. The said decision was confirmed by an order dated 17th May in appeal, referred by the board. In yet another decision, the Supreme Court in the case of Jaivir Singh versus State of Uttarakhand held that DL-ED NIOS is not equivalent to a regular full-time 2-year DL-ED course. This has put the writ petition number 5 to 12 in a quandary, as they had applied as DL-ED NIOS as their primary qualification. They also possess the regular DL-ED degree. This also to be noted. The arguments of the petitioner. Well, I am not troubling my lord with the argument of the petitioner. If necessary, I will repeat. But argument of board is very important. Now kindly turn to Milord page
16.
Sorry, Milord. Argument of the West Bengal Board of Primary Education. Mr. Shanal, my esteemed learned friend, appearing for the Board of Primary Education, has vehemently and aggressively opposed the writ petition prayers. He has submitted that the board is in serious confusion, having been tossed from one end to other by various courts. The recruitment process may never come to an end. There is a serious dearth of teachers in the state. It is also submitted that the decision of the Rajasthan High Court, rendered on 25th November 2021, should have been a wake-up call for the writ petitioners. I would add here, it ought to have been the more trustworthy duty on the part of the board. They are the trustee, not the writ petitioners. They could not have switched over from B.Ed candidates against immediately thereupon. They did not avail option switching opportunity provided to them on 14 December 2022, and subsequently a notification dated 5th June 2023 based on a division bench decision in Mrinmoy Sarkar. They should not now be permitted to switch option. This is the crux of the argument. It is next argued that the prayer made by the writ petitioners is in direct conflict with the decision of the Supreme Court in Shomenpal. Now the court analysis. My lord, will kindly come to paragraph 26.
Yes.
In the Shomenpal, proceedings pending before the Supreme Court, the issue is in respect of one section of candidates in the aforesaid recruitment process in course DL-ED candidates. The Supreme Court has already protected the appellants therein and has not pronounced anything with regard to other category of candidates who participated in the recruitment process. The order of the Supreme Court in Shomenpal thereafter cannot stand in the way of grant of lawful relief, if any, to the writ petitioners. There is no dispute to the fact that the writ petitioners and each of them hold the DL-ED degree issued by the primary board. As on date, this is the only qualification that has not been questioned by any party or any side or in any part of this country as a valid qualification for the purpose of being qualified as a primary teacher in this country. The NCT prescribes and recognizes the same as does the state of West Bengal. Therefore, this is the only recognized course now. It would,
DEIED.
it would therefore be grossly inequitable and unfair not to permit the petitioners to migrate as candidates having the DL8 degrees in the aforesaid recruitment process. The argument of Mrinmoy Sarkar gave a chance of switchover to the petitioner is misplaced. In the said case, the petitioners were not parties. The petitioners therein were seeking to switch over from DL8 status to B8 status. The argument of Mr. Sanyal that the petitioners were fence-sitters and contemplated jumping from one branch to another and hence must be deemed to an opportunistic cannot be used as an argument to negate rights under Article 16. This court is conscious of the fact that primary board has had to face many hurdles, flip-flops in undertaking subject recruitment process in September 2022. That by itself cannot deprive citizens of this country from a chance to seek public employment opportunity when they are qualified to do so. The confusion in the instant case is a result of illegal and unclarified communication of the NCT in issuing the circular dated such and such in recognized B.A. degree as an acceptable qualification for primary teachers. The subsequent striking down thereof by the Rajasthan High Court and the Supreme Court of India cannot frustrate the rights of the petitioners. These are all conclusive findings. The writ petitioners cannot be made to suffer on account of any mistake or illegality or impropriety on the part of the state. The primary board also cannot evade responsibility for the fiasco as they have illegally permitted B.Ed holders, DL-ED NIOS holders, and in-course DL-ED persons to participate in the recruitment process. Naturally, the candidates chose the degree in which they had the highest marks as the basis of their application. It is only in August 2023 that the law stood settled that a B.Ed degree is not a valid qualification for the post of primary teachers. It is only on 28th of November 2023 that it was held in Jaiveer Singh decision that the DL-ED issued by the NIOS is not equivalent to regular DL-ED certificate issued by the Primary Education Board or other institutions. The argument of Mr. Sanyal that the Rajasthan High Court had pronounced the same in November 2022 and the argument based on Article 226(2) of the Constitution cannot be accepted by this court to deprive the writ petitioners for any chance to participate in the selection process of government teachers. The matter was thereafter pending before the Supreme Court until August 23. What has weighed with this court in favor of writ petitioners in allowing interim relief is that they had at all material times possessed DL-ED qualification from the primary board. To deprive the petitioners of the right to switch over as DL-ED candidates would amount to depriving them of rights under Article 16. And then when the interim order was passed,
Allowing to.
yes. Now from that an appeal was taken. Next page, page 21. Appeal by the primary board.
Yes.
Now, I'm not troubling because the similar argument was advanced. Then kindly come to page 3 of the order at page 23. The arguments of the appellants were rightly discounted by the learned single judge, and the interim order was passed upon arriving at a prima facie finding. The respondents cannot be deprived from the chance to seek public employment opportunity when they are qualified to do so. Such interim direction was passed appreciating that the grant of such protection would not cause a greater loss and prejudice to the appellants
Then
than the loss and prejudice in the absence thereof would likely to be caused to the petitioners. Therefore, it was refused. Now, the board again went up the Honorable Supreme Court. Page 24.
Yes.
Upon hearing the counsel, but this is important, court made the following orders. Delay condoned. Mr. Gupta, learned counsel appearing for the petitioners. As the matter is still pending before the High Court in which interim direction is issued, we are not inclined to interfere. Specially is dismissed.
Final outcome.
Now, therefore, in my humble submission, after this, they have published the merit list. I have annexed that. In compliance of the order, in terms of our merit ranking, the merit list is published at page 33.
Yes.
Pertaining to publication of marks and ranks of the writ petitioners in respect of 2022 recruitment process, All these petitioner mentioned and the list is annexed. We are all.
In the list.
Not only Milord, we are in the merit list and Milord above the cut-off mark. Therefore, we are entitled to get Milord appointment.
Admit.
Now, kindly now, just to satisfy your lordship's judicial conscience, if your lordship kindly takes up the writ petition page 89, what was the initial advertisement by the board?
Yes. Page
89.
Yeah.
Now, the straightway kindly come to Milord the qualification. Milord, all the petitioners are TET qualified. That is apparent. This is a recruitment of TET qualified trained candidates. Milord, no person shall be appointed by the concerned district primary school council as an assistant teacher unless he or she is a citizen of India and has completed age of 18 years so and so. Then B, the candidate shall possess the minimum educational and training qualifications as prescribed by the NCTE prevailing as on date of publication of recruitment notification. Now, on the date of publication of notification, Milord, both the degrees which are prescribed by NCTE, Milord, we have been possessing, both DLED and B.Ed.
DLED and D.Ed.
B.Ed.
Slash B.Ed training. TET qualified
Yes.
undergoing DEID.
That has been negated. I am not on that.
Okay.
Therefore, the principal issue is on the date of advertisement, I am a qualified person.
Okay.
In terms of the notification of the NCTE and in terms of notification of the board. Now, subsequently thereafter, because of the judicial decisions, ultimately said that B.Ed is not to be considered. That if I had only B.Ed, I am out.
Out. If you have two, so one can be considered. You
That's
cannot
the-
say you are having the B.Ed, the D.Ed cannot be considered. Okay.
So that's the reason why the learned single judge, while pursuing interim order, had considered all aspects. And if I may say so with deepest of respect, my lord, in fact, conclusively, though at the interim stage, but the learned judge, my lord, had gone into the matter in detail and have come to a conclusive decision. Though it is said interim, but nothing new can be argued by both of the parties and nothing new can be invited up.
That's why this court is thinking what remains.
Yes, what remains.
Because the Supreme Court is also not done.
Yes.
I don't
Now, my lord, and again, my lord, in due compliance of the order of the court, they have published the merit list. They are also, my lord, we are really within the range of merit to be recruited. Why should we be deprived?
Okay.
Simply because the court said that the final writ petition. But these are in short, my lord, I don't want to argue in detail. If something arises for query, I shall say.
Yes. Yes, Mr. Sanyal, how?
I'm not. We have also given our, my lord, degrees mentioned in paragraph 6 of the petition.
Already mentioned it, isn't it?
Well, my first submission, your lordship should not be swayed by the interim order. I will show that the interim order is erroneous. And division bench said this is prima facie okay,
Correct.
but allow them to appear. And the Supreme Court also, my lord, my learned friend has taken to that. Now, my lord, your lordships kindly first consider B.Ed degree was never a qualification for recruitment of primary teachers.
B.Ed, okay.
Never.
No.
My lord, our High Court decision is also that division bench. My lord, Dilip Ghosh's matter. My lord, the first time NCT in 2018 notification says B.Ed will be one of the training
Criteria.
recruitment qualifications. My lord, this is not done by the board because NCT is the apex body. They did it. And since they did it, we had to include it. So this is not the fault of the board. Your lordships, I will take your lordships to the interim order passed by the learned single judge. The board illegally included. Board never included. Because board had to abide by the NCT notification. Point is, your lordships, having knew that the pan-India notification litigation pending, Rajasthan High Court quashed that notification. Supreme Court said, if you apply, subject to the result. Now, one having knew that chosen B.Ed Can he migrate? You filled in the application knowing full well they were put on notice that look, you are choosing this qualification subject to this. So they did it consciously. They cannot subsequently change it. Well, this is an approbate and reprobate and doctrine of election. Now I take your lordships to this. First, your lordships kindly take up this bunch of documents. No, the similar point is being argued before the division bench. He studied extensively hard and matter again kept on 19th. Only difference, they are from B.Ed switching over to DLED, and they are your lordships. They were pursuing, but then they were again migrated. Whether this can be done, I would. Issue is the same, migration. Now your lordships kindly take up your lordship page 15 and 16. Lord, this is, my lord, kindly take note of Devesh Sharma.
15 and
Page 15, this cause title.
Yes.
I tell you, lordships, Devesh Sharma matter comes from Rajasthan, whereby 2018 notification of NCT declared unconstitutional and void. And also recorded that the B.Ed qualified candidates are not competent to be recruited. Well, this is order, your lordships, 4th December 2022.
Yes.
Kindly take note of
4th February.
4th February.
Yes.
Recruitment notification of the present matter issued on 25th September 2022. 25th September 2022.
25th September
2022. So, the very fact that the one of the Honorable High Court.
This is a recruitment notice.
25th September. I will take your lordship, but kindly take note of the date.
May I take the leave?
Yes, yes. Yes.
So, when the recruitment notification, this was included, the list was pending before the Supreme Court. The Supreme Court issued notice, your lordship, page 16.
Yes.
Then your lordships, kindly come to your lordships, page 17. Devesh Sharma, again an interim order was passed, first issue of notice. This is 15th March 2022.
Yes.
Kindly come to page 19. The third paragraph. In the meanwhile, it is provided that the appointments made in terms of the impugned judgment of the High Court shall have the stipulation that the same shall be subject to the further order passed by this court.
Correct.
I'm frank, your lordship, making submissions. The appointments under the impugned judgment means Rajasthan.
Rajasthan.
Then your lordships kindly come to page 20. This is Somen Pal's matter. I request your lordships to go by the name. That would be very easy for your lordships, convenient for your lordships. Well, kindly, may I place this? This is the beginning of everything and created, if I am not wrong, this court. This honorable court. In this matter, I am told by the learned advocate for the board that on 29 September 2022, the result of DLED Part 1 will be declared and the digital mark sheet will be sent to different institutes. All the persons who were undergoing that course will get the digital mark sheet tomorrow. It is further been stated by the instructions by learned advocate for the board that TET qualified candidates who are undergoing DLED training session, qualified Part 1 such and such examination, will be given opportunity to apply the recruitment process to be initiated by the board. He has also submitted that this opportunity will be given to all the persons who are undergoing DLED course of such and such. I find that the grievance of the petitioners is redressed by this taken board, which is beneficial to all. But why I am placing it, facts little different of the present case of that one. In the morning, this matter was taken up. The honorable judges of the view, unless you include this, I will stay entire process. In the evening, notification was issued including this. Because a rule doesn't permit pursuing candidates to be qualified. Here, this is not the issue. Here, your lordships, they filled in. Now, your lordships, I will take your lordships to the notification. Kindly come to your lordships. Then I will.
No, page 21.
Page 21.
The same order, second paragraph.
Second paragraph.
He submit that the opportunity
will be given to all the persons who are undergoing. So they are not undergoing, Malad. They are not undergoing. But
No,
I am
that's-
saying, Malad, this is first came out.
That's why this came. Okay.
Undergoing. Then your lawsuits, this was passed in the morning, 29 September, and the recruitment notification was passed your lordships. I give your lordships the date. 29, the
20
page rather, I take it.
29 September,
29 September,
page 22.
to page 20. I just give you lordships.
After that order, I think.
Yes, my lord, 20. Yes, your lordships. Kindly see, first your lordships will find qualification 3A, that's my lord, normal qualification, eligibility criteria. B, the candidate who shall possess the minimum educational and training qualification as prescribed by the National Council for Teacher prevailing as on the day. Pause here for a moment. It means B.Ed, because 2018, my lord, NCT says it, I can't go beyond this. Kindly consider your lordship learned single judge in paragraph 32 says board illegally included. How? How the board included, my lord, illegally? Of course, division bench and Supreme Court says an interim order, prima facie view, since this petition is pending, my lord, you just allow them. So now your lordship has to consider it, how the board did illegally. Now the second clause, your lordships, in pursuant to the earlier order,
No, so then B, the candidate shall possess a minimum education qualification
as prescribed by the NCT.
by the NC.
NCT. My lord, NCT, my lord, the first notification 2010 and 11, only 2 years DLED.
Where is that? You are
I have your lordships.
Yeah,
I have.
all funds, well, they are all NCT notification as well as earlier page.
They have.
10 as well as
My lord, kindly first take, my lord, 2010 notification.
2010.
earlier
Just I give your lordships. Just a minute. ma'am.
flag.
Kindly your lordships, 2010 notification. 23rd August. My lord, we are concerned about classes 1 to 4. 5.
Just a minute. 2010.
2010.
Yes.
This is the initial notification. After, my lord, Right to Education Act came into force and NCT became the academic authority.
Hmm.
Lord, kindly see the clause A. Secondary, senior secondary with at least 50% marks and 2-year diploma in elementary education. Then your lordships,
Secondary 50%.
and 2-year diploma in elementary, malad commonly known as DLED. Senior secondary with at least 50% marks and 2-year diploma in elementary education in accordance with NCT regulations. Then senior secondary with at least 50% marks and 4-year bachelor of elementary education.
Yes.
And then senior secondary with at least 50% marks and 2-year diploma in education.
Correct.
And then pass the teacher eligibility test. So, malad, B.Ed was not the qualification. Then your lordship, this was little amended, but there is no amendment in regard to this. Malad, your lordships will find 29 July 2011.
Yes.
Notification. Kindly, your lordship, I don't know the page, I will probably
Yes, it is there.
there.
No.
Malad, kindly see again. Your lordship, just have a tally your lordships with that. Your lordships will never find B.Ed over here.
For 1 to 5.
For 1 to 5. Primary, elementary. B.Ed is not.
Yes.
Now, your lordships will find now 2018 notification. That's at page. 2018 66, 69. Malad, your lordships, I don't know your lordships.
28 June 2018.
Exactly. Kindly see.
Yes.
28 June 2018, man.
Yes.
Now, kindly see, in exercise of the powers conferred by subsection 1
Yes.
of section 23 of right to children to free and such act issued by the government, Department of School and Ministry of Resources, the National Council for Teacher Education makes the following further amendments to the notification dated 23rd August 2010. The basic notification, your lordships. What Malad says, Malad, kindly see, in the said notification, in para 1 of subpara Roman I in clause A, after the words and brackets graduation and 2-year diploma in elementary education, or graduation with 50% marks and bachelor of education. First time introduced. And graduation with 50% marks and bachelor. Malad, bachelor of B.Ed was never was the qualification. Then your losses kindly consider proviso. How the NCT did. A, who has acquired the qualification of Bachelor of Education from a NCT recognized institution shall be considered for appointment as a teacher in classes 1 to 5, provided the person so appointed as a teacher shall mandatorily undergo a 6 months bridge course in elementary education. Well, this was a bone of contention also before the Supreme Court, and Supreme Court heavily came down over the NCT. How could you qualify in them? It very proviso shows they were not qualified. Because your lordship, the subjects were different. Courses were different.
How it has come weird degree in the teaching?
That's therefore, all that I'm trying to point out, if your lordship kindly consider the learned single judge's interim order, para 32. Board illegally did it. How the board illegally did it? Because of this. And my endeavor to your lordships, everybody knew about it. And then filed the application because they had the higher marks in B.Ed. They wanted to take the opportunity of that. And then ultimately failed. And then try to migrate themselves. This is not permissible.
Yes.
Then your lordships kindly আগে পরে বলো এই অভ্যাসটা ছেড়ে দাও নাহলে
2011 এর নোটিশে দেওয়া আন্ডারগো কোর্স
সেটা অন্য কারণে this is not for that.
it was there.
Malad, I take your losses. Your losses kindly come to page notification 2010 again.
2010.
10. Just your losses, sir. 2010, 11, whatever your losses. 11. All right, 11.
Undergo course.
Yes, I take your losses. Where that's 2011 to page 56, 57. Malad, kindly come to your lordships, page 11, your lordships, 2011.
Yes. 29 July 2011.
Exactly. Now your losses kindly, I have placed your losses classes 1 to 5.
Correct.
Then your losses kindly come to next page.
6 to 8.
No, 6 to 8, no, not. For para 3 of the principal notification.
Achha.
Probably they will point out why this was introduced. I just explained it. Training to be undergone. A person with graduation with at least 50% mark and B.Ed qualification, or with at least 45 marks and first year B.Ed education.
Where from you reading?
Malad, this
Notification dated 29 July 2011.
Notification dated 29 July 2011.
Correct.
Malad, the para Roman III, capital I. The next page, probably the second page of the notification, top.
Yes, yes. For
para 3 of the principal notification. This was also there to some extent in principal notification. Training to be undergone. A person with graduation with at least 50% marks and B.Ed qualification, or with at least 45 marks and first year B.Ed bachelor education in accordance in regulation issued, provided that he undergoes after appointment NCT 6-month special core education. Then with DLED shall undergo after appointment of 6-month special education. Now, kindly your lordships consider this. This was your lordships.
Yes.
Malad, eligible for appointment to classes up to 1st January 2012. Your lordships got it?
Yes, yes.
So this was made valid for 1 year. I am giving the Malad explanation why NCT did it. For the first time, DLED courses introduced 2010. So there was throughout the country, there was not sufficient institution even. So how the infrastructure to be done, how the teacher to be appointed. So they permitted for 1 year B.Ed qualification, not beyond that. But subject to 6 years, a 6 months bridge course. This was a stopgap arrangement so that the students do not suffer because of trained teachers. Am I clear to your lordships?
I think since beginning for the primary school teacher, there was that is called the primary school teachers training, PST training.
This is PTTI.
PTTI, that was the 2 years course.
1 year course.
1 year's course, 1 year course. And that if it is completed, that time TET and CET was not there.
But after 2 year DLE, first time introduced in 2010, none of the state governments didn't have. That's why even the training qualification or relaxation was given. I am giving explanation so that your lordships was not given to misunderstand us. So they will say this was earlier permitted.
Para 3 of the principal notification.
Your lordships kindly look at para 3 was there also there.
23rd August.
23rd August. August of 2010.
23rd August.
Kindly look at this.
Teachers appointed.
Same thing was there, almost. Up to 1st January 2012.
Okay.
Not before that. This was a stopgap arrangement by the notification. So after 12, BA was again not qualified. And then your lawsuit 2018 for the first time make it permanently qualified.
Yes.
So board didn't do any illegality. That's why in the notification this was included. Now your losses kindly, after the notification page, your losses kindly come to Devesh Sharma further interim order, page 24 of the spiral binding. Oh, just not spiral.
No, it's got no problem.
But kindly, this is an order dated 12th August 2022 after the recruitment notification published.
Order dated 12th August.
Page 25. Dates are relevant, your lordships.
Yes.
Kindly see page 28, what order was passed.
12th August 2022.
Any state, all these matters, because all state came forward now. Any state during pendency of these proceedings having impact on the controversy out of which these proceedings arise shall be subject to the final outcome or any further order that may be passed in these matters. Therefore, your losses board recruitment notification inclusion of B.Ed was subject to this order. That's my submission.
Final outcome, yes.
That's now your losses. Kindly see the next page. Not the next page. Page 30.
Yes.
Well, kindly see. This is 1st November 2022, issued by the board after the Supreme Court's interim order. In the matter of SLP number such and other connected matters to allow B.Ed candidates to participate in the recruitment process of 2022, with reference to the notification by your lordship 29 September, the recruitment notification. It is hereby notified. Please be informed that having regard to the development reported to the board verbally by you, well, this is probably the lawyers. The board, being the recommending authority for recruitment, has no difficulty to allow B.Ed candidates to participate in the recruitment process of 2022 for the post of assistant teacher in primary schools in West Bengal, subject to the solemn verdict of SLP number and other connected matters pending before the Honorable Supreme Court of India in respect of their participation in the said recruitment process. So everybody was made known that you be conscious of that what you are doing. Then kindly see your lordships. Page
SLP number.
Yes.
In this advertisement, SLP number, the notification. That is most important.
No, that's not the notification. SLP number wrong. Next page, your lordships. Page 14, December 2022.
Yeah.
Yes. Well, this was the last date of submission of the application under the recruitment process. Online application recruitment of TET qualified trained candidates to the post of assistant teacher, wide notification 29 September 2022. It is hereby notified that edit option will be available on online portal of recruitment of primary teachers for TET qualified trained candidates from 14 December 2022 till 18 December 2022 to edit the data already submitted by the TET qualified candidates if required by clicking edit option. So they were given an opportunity. Now kindly come to your lordships, the read petitions page. I give you lordships.
So this is on 14 December 2012.
Exactly. The last day, this was given. Your lordships will be fine. Kindly take up tally to tally with this page 8 of the read petition.
Yes.
Kindly see name of the petitioners 12 of the present petition. Training with details which was submitted to fill up the form. With this qualification, they submitted the form.
Yes.
Then other training details.
Yes.
Kindly see also the first 4. They had both.
Yes.
They had chosen B.Ed. They have the right to choose because notification said it. Now, because of the Supreme Court interim order, we gave them the option. Look, you will be in difficulty if ultimately the order of the Supreme Court goes against the B.Ed candidates. You may edit your data.
Yes.
They did not do that pursuant to this notification.
No.
They did not do that.
Who has issued this notification?
Board,
Board has
executing
issued,
authority,
board has issued the notification for addition.
they edit data.
Correct.
So, what I'm trying to say, your lordships, that the first day they were put on notice, the Supreme Court order that look, this is, and everybody knew about it apart from the notification. Then you did not do it. You chose not to do it.
Correct.
Then you have to stick to that. This is your election. How can you ask for migration of that?
So why this notification was issued by the board?
Because your losses to give them an opportunity. Because somebody filed B.Ed, somebody
Correct.
can change it.
Okay, because they, with regard to the proceedings, the candidates may not be knowing what is the proceeding. Okay, there we say. But once the notification has been issued by the authority of the local authority for editing and changing the qualification, whatever it is. So
They ought to have done it. They didn't do it. They stick to their B.Ed. Because Supreme Court
can the game is started? You can change the rule.
I tell you, lordships, because of the Supreme Court decision we did it. I have not.
Supreme Court only stated that this is abide by. Kindly come to the Supreme Court judgment, Supreme Court order.
Any step taken during the pendency of these proceedings having impact on the controversy out of which these proceedings arise shall subject to final outcome or further on.
Correct.
So we gave an option. He do it, he may not do it. He stick to it. Then how can you after that change? This was done before interview, before the last date of application. We didn't change any qualifications because NCT notification still holding the field. Because until the judgment of the Honorable Supreme Court, though I have one submissions. If a pan-India notification passed by one High Court under Article 226, can it be given effect to by the other states? That's another point, but I am not raising that. But because since Supreme Court pending, all the state authorities appeared, made their submissions, days together. So we gave them. It's not them. It's not amounting to change of a rule of the game. We wanted to notice you that you look because of this. If you don't do it, don't do it.
So this was issued on 14/12.
Exactly.
What was the last date of the
submission of form? 14 December.
14 December.
And your lordships will get it.
And you extended till 18th of December.
Only. Page 29, your lordships will find.
Page 29
of this bunch of documents. 14 November. I'm sorry, I'm 14 November.
14
November. I may be, I'm not in a position right now to
yes,
say.
14 November 22.
And this was issued on, first notification was 1st November 2022. Page 30.
Correct.
Putting everybody, because this is website, no one can say. This was given in the website of the board.
Correct.
Online application. Everybody should know. No one can say that I didn't know.
So it is on 1st November.
First we make them aware. Just a SLP number is mistaken. That cannot be a ground. Kindly see your lordships. The subject matter of the contents.
Development reported the board working recommending authority for the recruitment has to no difficulty to allow the B.Ed candidates participate. Subject to recommendation.
May I apprise this court of factual aspect? Because this was given.
Kindly do not allow
because of that.
Then I will come to it. That you take note of it. You take note of it.
Then I will make submission.
Yes.
In the midst of it. Now your lordships will find page 24.
24 of?
24 of this bunch of documents.
Compilation. Yes.
SLP number 20743 of 2021.
Correct.
And this was made type of 2022, page 30 your losses. Number is the same.
No, that is okay, no problem.
So first we put on notice and then we gave them the opportunity for their benefit. This is not the rule. I'm not changing the qualifications. Both the qualifications at that point of time was valid, subject to the Supreme Court. But you have, so you could have exercised this. They didn't. Then your losses kindly come to page 32. My lord, this was the order dated.
So what has happened after this 14/12/2022?
14/12/2022.
After this notification, what has happened?
My lord, they didn't do it. No, they didn't do it. They came as B.Ed. We had to process like B.Ed. Then your losses kindly see what happened. My lord, then judgment. My lord, page 35, 12th January 2023. The Devesh Sharma matters were argument was concluded and the matter was made. The judgment was reserved. That at page 35, your losses will get it. 35 and 38.
38.
35 your losses, 1st January 2023, order date, and 35 arguments concluded.
Correct.
Then your losses kindly come to page 39.
Yes.
Well, this is your losses against the first order, your losses pursuing candidates order, 29 September 2022. And an appeal preferred. Appeal preferred your losses by the private candidates that pursuing candidates cannot be allowed. Then your lordship, I'm placing this order, though factually this is not, but some relevance is there. That's why I'm placing this lordships. Kindly your lordships skip over the entire thing, your lordships will find. Then your lordships kindly come to the operative portion of this order at page 55.
Yes.
My lord, here, my lord, paragraph, having heard the parties, kindly see, my lord, having heard the parties and considering the materials placed, this court of the clear view that the board cannot travel beyond its own recruitment rules. Apropos the above discussion, Rule 26, rule as amended, unambiguously specifies the eligibility qualification required as on the date of advertisement. The nature of such qualification is also specified by NCTE, the 2010 notification. This court further notices the law is well settled, all that, my lord. Court ultimately held the board cannot allow pursuing candidates, both DLED and BA. Your lordships will find page 56. Second paragraph. Then your lordships, both the notification was quashed. The 3B clause, that clause 3B I placed, your lordships, that was quashed. Your lordships will find it. Last paragraph. Clause 3B of the recruitment notification dated 29 September, followed by further notification to the extent that permit would not have the minimum, because it stands quashed. So, my lord, only those candidates who had BA and DLED pass, they were allowed. Now, your lordships will find page 58. Because of this judgment of the division bench, my lord, we had to cancel those applications of the pursuing candidates. By this notification, we declared those are cancelled. Your lordships kindly see. It is hereby to notify by dint of the common judgment dated such and such, which was clause 3B of the recruitment notification, followed by to the extent of permitting who did not have the quast. My learned friends are not affected by that. Then your lordships, after this, your lordships, an application was moved by the my learned friend probably moved it, page 59.
That is the
pursuing candidates, some of them had B.Ed qualification. They are DLED pursuing B.Ed. They came up and say, allow us to switch over to B.Ed. I have already B.Ed. B.Ed is as per notification valid. Now, this is that order of 1st September, May 2023, whereby the writ petition was allowed. That will also kindly come to page 60.
Page
60. Well, this point is being heard now before the division.
60.
Page 60. Last but one paragraph. In this matter, as you have seen, in last but one paragraph. In this matter, I have permitted not only the petitioners to appear in the interview, but also other similarly circumstances, means those who have B.Ed. For the reasons that if such order is not passed, other persons who may not have recourse to approach the court, who are not in the know of the order of this court, along with B.Ed degree holders, may be deprived. So those are B.Ed also again allowed by this court. We against this judgment order, we preferred an appeal. We lost. But how lost your losses kindly consider. Page 62.
Lost is lost.
No, my lord, it's with a rider. Page 62, my lord, starting against that order. I take your lordships to the page 66.
Yes.
Having anxiously heard the third paragraph, having anxiously heard the parties and closely considering the materials placed, this court finds that by judgment and order of the division bench, the division bench refers to their own judgment. The part of the recruitment notification creating eligibility for in-training DLED who are obtained stood struck down. In the further view of the court, the striking down by the in-course training qualification of DLED in the facts as discussed in the judgment does not create a bar to consider the candidature of the writ petitioners. That means only B.Ed qualification. Only on the basis of their standalone B.Ed qualification, which it is not disputed is also an eligibility criteria participate in the recruitment process. Because Supreme Court matter is pending, kindly see now what the court says. This court also records that the parties who have submitted the position of the B.Ed degree being an eligibility criteria is currently pending challenge before the Honorable Supreme Court. That's why I'm saying, Lord, though lost, but with this rider. Then next. Needless to add that the direction passed in this appeal shall be subject to the appropriate direction by the Honorable. Now, I put a question to myself. These sort of candidates who are pursuing DLED, they can switch over to B.Ed pursuant to this order. Now, ultimately, Devesh Sharma says B.Ed not qualified. What will happen to them? Can they proceed further? Because with this rider you applied, you changed your qualification. Now, they are your lordships, present petitioners, are on the same footing almost. Because they filed with B.Ed qualification, it's all this rider.
No, that's why the needless to therefore add the directions passed in the appeal shall be subject to the appropriate adjudication of the apex court.
Appropriate directions, Honorable Supreme Court.
Correct.
Supreme Court was one argument, and no, this argument. That this is confined to them. How? This is confined to them, okay. But you are on the same footing because you also applied with B.Ed and you were put on notice by the board itself. Page 30.
So your main question is that once you have lost your opportunity, you cannot come.
You cannot change it.
That is your main submission.
Main submission. That will change. Now your lordship, how the Supreme Court proceeds. Then your lordships, my lord, kindly consider page 69.
Yes.
Home and pulse matter. Your lordship, that 3B clause was by the division bench, appeal was taken out.
Yes.
Now your lordship, this is an order of 8/28 July 2023.
28, yes.
Now, kindly see my page 70. Last paragraph. Until further orders, the respondent board of primary education is restrained from declaring the merit list. Initially, this was stayed. Then your lordship, board took out an application, all that. Now your lordships will find. After this, state, kindly will look at page 71.
Yes. Devesh Sharma.
Devesh Sharma. Kindly page 73. Date 11th August 2023.
Yes.
Well, I'm not taking to the entire judgment. Kindly come to page 76. Well, kindly see the last two paragraphs. The first paragraph pronounced the judgment of the bench such and such. Last two, civil appeals are dismissed. The writ petitions are disposed of in terms of the reportable judgment, pending applications. Well, civil appeals all are by the Rajasthan board and our board. All civil appeal dismissed. Holding 2018 notification of the NCT unconstitutional and void ab initio with the rider that B.Ed qualified candidates are incompetent. If you also wants that, I can take your losses to that. Judgment of the court. Copy as it.
Sharma.
Barco. Just a moment.
Devesh Sharma লাগবে?
ওদের কাছ থেকে নিচ্ছি দেখ। I just take your losses. Probably That paragraph will not tally. Just kindly come to page 33. Only the very will be comprised. Paragraph 33, last paragraph. Page 33. We have already examined this aspect in great detail. B.Ed is not a qualification for teaching at primary level of classes. Finally, much less a better or higher qualification in the context of primary classes. This finding is self-evident in the very admission of NCT, which mandates that all B.Ed qualified teachers who are appointed to teach primary level classes must mandatorily undergo a pedagogical course of preliminary within 2 years of their appointment. That's why the clause you have shown. Even 11, the reason was the principal notification, there was data. But subsequently, on the 2018, they made it permanent B.Ed qualification, a permanent recruitment qualification. Even the Supreme Court says, how could you do it?
Correct.
Then your losses will find. Page 35.
Yes.
Kindly keep over.
The defect is very logic, including B.Ed.
Unlike diploma in elementary, faster first 3 lines. I'm not the very top you lost.
Yes, yes.
B.Ed is a different qualification, a different training. Even assuming it is a higher qualification, it would still not be a suitable qualification for primary level of classes. Unlike diploma in elementary education, B.Ed does not equip a teacher to teach at primary level. This fact is implicitly recognized in the notification as well as notification dated 28 June 2018, that notification, which still requires a person who is appointed as a teacher with B.Ed qualification to mandatorily undergo a 6-month bridge course in the elementary education.
Yes.
Now, this is the very law. Now, you'll also see the entire notification was quashed as unconstitutional. Now you'll also find paragraph 34. The reasons given by the Supreme Court, affirming the Rajasthan High judgment, how the Rajasthan High Court proceeded with this and quashed the entire scheme.
Yes. Valid till is declared unconstitutional by the court. Yes. Next. How much time will it take?
Well, I will take more. Philosophy takes it up any other day, I don't have any. But except Friday and Monday, I have personal difficulty. Any day I will be. আমার প্রবলেম হবে
ये फिक्स मैटर আছে কি
অনেক ফার্দার ডেভেলপমেন্ট
12 बजे है क्या मैटर कौन सा
তুমি এবার সুপ্রিম কোর্টে বাকি জাজমেন্ট গুলো তৈরি করো তো
एक ही है yes come adjourning the matter who is on the fixed matter 12 p.m. matter and who is there you are there the counsel for the petitioner has concluded the argument. Counsel for the respondent board has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear. February.
Yes.
Under the same heading within 5 matters.
কোশ্চেন দেখে না
ঠিক আছে
সেদিন তো আপনি শেষ করছেন না
you're also skipping it in the morning.
yes রেখেছি
No, ওটা morning না, ওটা 2 p.m. আছে।
সেদিনকে আপনি পুরোটা নেবেন তাহলে সেই অনুযায়ী স্যার
করবো।
my lord, may I return back the
Yes,
spiral
sir,
if
take
my lords want? I will give another copy sample.
Those 3 notifications will give a lot of.
Yellow वापस yes call the
But I will give the
yes
whole one.
take back इसको रखो ये दे दो yes next
স্পাইরালটা দিয়ে দিন আমার স্পাইরালটা হ্যাঁ
11, 12, 13, 7.
11 12 13 my lords the same order
11 12 13 same
same order same আমাদের নাম